Hello, this is Pasquale Pistone, and I am the academic chairman of IBFD and the co-director of the Observatory on the Protection of Taxpayers' Rights. I'm here to share with you some content concerning the 2019 annual report of the Observatory. And I will do that in a few minutes, also sharing with you some slides. Before doing that, I would like to remind you that the Observatory is a non-judgmental source of information concerning the protection of taxpayers' rights around the world. It is the follow-up to a line of research that started with a general report for IFA that Philip Baker and I co-drafted on the protection of taxpayers' rights. And since then, we have established the IBFD Observatory on the protection of taxpayers' rights, giving update on the developments concerning the protection of taxpayers' rights around the world. This is a project that is connected also with additional research projects, and in particular, one of this research project has reached its peak in 2019. That is the ETLP main topic on tax procedures, and this is actually also the reason why I have thought about selecting tax procedures for the excerpts from the Protection of Taxpayers' Rights Yearbook for my video clip today. As you can see, there will be reference to specific sections of the report, and before going to the specific sections concerning tax procedures, I have thought about selecting a very important judgment from 2019 from Europe. It's a landmark judgment from the Court of Justice on administrative tax procedures. It's a Glencore judgment from the Court of Justice. And in a few minutes, I will tell you more about it. As I said, this is a research project which is connected also with other research projects. And these other research projects also include the International Law Association Study Group on the protection of taxpayers' rights from the perspective of public international law. A release of the final report of phase 1 is expected before the end of 2020. Let me now go to address the technical issues connected with the Glencore judgment. The Glencore judgment is unquestionably a landmark judgment from the Court of Justice. And this is for the impact of this judgment on the right to fair trial and defense during the administrative tax procedures. Now, what is this expression, administrative tax procedures? We are using here the same terminology that has been used in the ETLP, European Association of Tax Law Professors, 2019 book, which is available also at IBFD. And the administrative tax procedures is the part of tax procedure which runs until the access to the judiciary. That basically covers all the parts, including particular audit and also the review of the audits. The Court of Justice in the Glencore case made it very clear, and this is a development from the Soprope judgment, previous judgment from the Court of Justice, that the protection has to be secured throughout the procedures. And it includes the right of access, so the right for the taxpayer to have access to all relevant information concerning the taxpayer itself. And it's interesting because in this context, there was a problem about the involvement of a third party in good faith in a fraudulent scheme. Now, tax authorities had been gathering data concerning the fraudulent scheme, and they have been using them in an audit with the person who had developed this fraudulent scheme. But the third party in good faith did not know anything about it and had not received full information. Now, the involvement of the third party is definitely something which is in line with the case law from the Court of Justice, insofar as the third party knew or should have reasonably known about the fraudulent scheme. But this judgment says that under any circumstance, it is important always to grant audita, consistency with the audita altera parte principle, and also with the fact that right of defense, which requires full access to the information for the affected person. As I said, this is a judgment which you definitely have to have a look at. It's available on curia.europa.eu. You have all the relevant data, and I'm sure it will give you an idea of the fact that it has contributed to an improvement of the protection of taxpayers' rights. Now let's go to the first of the three clusters, and that is the cluster of normal audits. As you can see on the bottom part of this slide, we have indicated some parts concerning the four core principles, the nebis vexari, proportionality, audi alteram partem nemo tenetur se ipsum accusarem, and this is going to be the focus of this year's video clip and excerpt from the developments of the yearbook. If we start with the nebis vexari is the procedural limb of the nebis in idem principle, so the procedural part of the prohibition of double jeopardy. On the one hand, the color codes, I think, are evident, are obvious. On the one hand, we can record an improvement in the protection of taxpayers' rights in Spain, where the judicial interpretation has indicated that new tax assessment is possible only if facts and documentation differ, and also that there may be no duplication for facts that have already been object of a prior provisional assessment. So what has been assessed, and that it's important because it excludes a possibility of reassessing in the absence of new facts. The right column is a red one, so it moves, it indicates that we have been shifting away from the standard of the protection of effective protection of taxpayers' rights. And there you see where in South Africa, the prohibition of double jeopardy is admitted in general, except to criminal charges, and that in Switzerland and Uruguay, there have been some narrowing down. In Switzerland on the interpretation, and in Uruguay, in a way that tax authorities are allowed by the judiciary to restart the audits when there have been procedural mistakes that affect their validity. If we move on to the proportionality, the second core principle, from a procedural perspective, encouraging developments have been recorded in Canada, where tax authorities use the foreseeable relevant standard also for determining whether the tax authorities may seek information from taxpayers, and also the fact that this is bundled together with a communication to them. So it's important because it sets a limit to the use of requests for information to the taxpayers. And in the US, there have been some limits introduced to repeated auditing in 2 consecutive years for the same taxpayer, except in the presence of some specific indicators that basically suggest that should be done. When we go to the right column, as you can see, there is a common trend which we are not too happy about, and that is tax authorities can just ask more than they need. And that has been recorded this time in particular from Guatemala, Mexico, and Slovenia. We're not saying the tax authorities should not be allowed to ask what they want, but it should be clear that there should be a reasonable ground to request that. If we move on to the third one, audi alteram partem, unfortunately, you see that the left column, the green column, is empty. That's not very reassuring also because when we move to the right column, the red column, we see that there's been a step back in the answer from the questionnaire. The consistency with this principle has gone down. And in particular, we could see that in some countries that was either abandoned because of reasons of preserving simplicity, as in Colombia, or in Serbia when taxpayers had failed to submit a tax return. Now, the failure to submit a tax return is certainly something that should be taken into account, but at the same time, there should still be a possibility to hear possible views by the taxpayer rather than just doing it on a sort of flat basis. Now, if we go to the nemo tenetur, I'm sure that the wisest thing that I should tell you is to have a look at what Carlos Wefe says in his video clip. So maybe you get curious to do that when it comes to take into account his remarks on the points concerning point 7 of our standards, so concerning sanctions. However, I have also made a selection, and that refers to the fact that the Constitutional Court of Portugal has interpreted some rules in a way that allow the taxpayer to be informed of any information that is gathered in the framework of an inspection, so it cannot be used in criminal proceedings unless the taxpayer is aware of that, so that he has a possibility to defend himself. And if we go to the right-hand side, the problem is that the nemo tenetur is stated in principle, but the structure of the legislation is sometimes preventing from, an actual functioning of this principle. You should expect some surprise from the ELAR research project, in particular for issues concerning, the culpability of the taxpayer and the fact that there should be an actual evidence. For the time being, China and Mexico have indicated that there is either no right to remain silent or that this is not protected. If we move on now to section 6, we're going to be a bit shorter on this, on reviews and appeals, so administrative reviews and judicial appeals. I have been questioning in the tax procedures project of the European Association of Tax Law Professors the need for prior exhaustion of the administrative review. Well, this is something which should officially operate as a filter, but in fact, in countries like Croatia, it has never, recently has simply been an endorsement of what tax authorities have previously come up with. So from this perspective, if it has to be a filter, the filter has to be effective. And frankly speaking, I see no reason why there should be a different mechanism or a different relationship between administrative review and judicial appeals, meaning that taxpayers may go for administrative review because they find it faster, and judicial review just because they need an involvement by the judiciary. But the fact that there is an obligation of prior exhaustion also increases significantly the time for judgment, and this is something that we will see also in the light of a 2020 judgment from the Court of Justice in the Santander case. We will see what repercussions it may determine. Denmark has abolished this obligation of prior exhaustion with effect as of 1st of July 2020. And as you can see, there have been interesting developments also in other countries where they speed up the phase of administrative review. Australia for small business, even as little as 28 days, and Bulgaria and Russia have introduced these services, and Peru e-appeals. But still, half of the countries reported still require a prior administrative review. So it could be interesting for you to have a look at the suggestion in the 2019 ETOP general report, which is connected to this research project and which sets it as an alternative option. Now let's go to section 8, which is also the final part of my video clip. It's about enforcement. And here, as you can see, we have some interesting developments that enhance the protection of taxpayers' rights in the situations of the so-called economic hardship. And this is certainly something which may become more and more important also in the 2020. We expect some developments in this direction, also considering the pandemics and the influence that may produce on the enforcement. So in Italy, there has been an uphill of a partial payment of debt in line with a pre-bankruptcy proposal. So this has been endorsed by the judiciary. And there has been a similar result achieved in Serbia in respect of delayed payments for restructuring or reorganization connected with the bankruptcy. And in the US, there have been some thresholds for intervening in this respect. Unfortunately, the opposite direction, enforcement without judicial authorization, so freezing bank accounts without judicial authorization in Mexico, seizing assets, and in Uruguay, the economic hardship is not being considered as a reason for avoiding tax enforcement. And this is actually something that takes us also to complete this video clip. If you want to know more, you're welcome either to download the entire yearbook, to visit us on the webpage of the observatory, or even to send us an email. Otherwise, we look forward to the next edition of the yearbook, which will be presented in Q2 2021, and it will be about the 2020 developments. Thanks very much.